nearly everything. There's drawings, photos, jingles, logos, music. Most of the written content in an ad will be protected by copyright. This does mean like one ad can have like a number of overlying copyright rights in it. And so you need to be across all of them. The general rule for an owner of copyright is that the owner is the creator of there's a few exceptions to this. One of the main ones is where a work is made by an employee of a business, then the employer generally attains ownership. So as owners of copyright, they have exclusive rights to reproduce and publish their creations, known as works, which I was just talking about, and can establish the conditions under which others can use their works. So sharing music, photos, and other material that others hold the copyright in without their permission is unlawful. So as a business, the first thing you want to do to make sure of before you publish your ad, whether this is posting on social media or sending an email to your database, or any of the other things we've been talking about, the first thing to make sure of is that your business owns the copyright or has a license to use the copyright in all aspects of the ad, all the overlay. Otherwise, you might be infringing the copyright of the creator, and you could potentially incur liability for damages. There's also the chance of reputational damage if you're the subject of a copyright claim, particularly if it's a famous artist or musician, because some of their copyright claims have been highly publicised. So important to bear in mind, even if your business has paid someone to design the ad, you don't automatically obtain the ownership of the copyright in those materials that they've designed. You probably have an implied license to use it for the purposes for which the design was requested. However, if you don't have a formal agreement in place, it can be unclear how far the license really extends, and you might not be able to use the ad for additional purposes that you thought. So the difficulties in working out the scope of an implied license was evident in a recent case of a photographer, Mr. Hardingham. He took photos of properties about to go on the market, and that was on behalf, and they were then uploaded to realestate.com.au. So Mr. Hardingham, there was an agreement, and he went through 3 court hearings to get all the way to the High Court. We then decided in this case that the license was quite poor, and that allowed realestate.com.au to use the photographs indefinitely. So even after the property was sold, they could still use them. And it was also determined that realestate.com.au had implied in its license a right to sublicense. And so it was allowed to sublicense to another organisation for them to upload photos to their website. And that was one that recorded historical data about property sales. So if these parties had formalised their arrangements more clearly, such as in a license agreement, then they each would have known what they could and couldn't do. So that would have saved them a fair bit on legal fees, time at court hearings. So therefore, best practice, even where people other than your employees are creating content for your business, the best thing to do is request an assignment of the copyright. And if you can't get that, you should formalise the implied license and make sure that the license gives you more rights to use and adapt and modify them. So while the High Court in the Hardingham case took a broader approach to their license, that's not necessarily going to happen from a factual situation that's a little bit different. So it's best to protect yourself by formalising everything, and then all the expectations can be written down. Also, when you formalise the arrangements, you can seek a waiver of moral rights. So moral rights are rights that belong to the creator for like attribution, and a right to have their works treated in a way that's disparaging or prejudicial to their reputation. So it's a good idea to have the creator consent to use of their work in the ad without attributing them as the author every time. Then if you're not sure about the identity of who's created your artwork. Sometimes you can make inquiries with a collection society. There's different collection societies for different avenues of art. For example, and the most well-known one is probably the APRA AMCOS, and that's a joining of the Australasian Performing Rights Association and the Australasian Mechanical Owners Association Society. So they can actually assist you to find relevant copyright owners of music, and that you can also license music from APRA to use for promotional or brand associated purposes. So whilst you can obtain this license from APRA, if you're syncing the music with audio-visual material, you probably still need a license with the copyright owners directly, in addition to APRA. There are a number of organisations who offer free or reasonably priced stock photos, and so you might be using them in your businesses as well in your advertising. So I guess just the word of caution with stock photos is to make sure you check the terms and conditions. In many cases for the free stock photos particularly, the author or the website needs to be credited when you make use of the photograph. Otherwise, you'll be in breach of the license conditions of which you're allowed to use it. There can also sometimes be limitations imposed on the uses that can be made of some of the images. Like they might even have a ban on use for commercial purposes. And so that means you can't actually use that photo in your ad. You also need to take care with the use of AI generated photos or images. A consideration about AI can take up a whole seminar of its own, and it does very often about many different things that we're all unsure about. But yeah, there's still a lot of areas in the law that haven't developed, and there's a lot of issues that haven't been tested yet, so it's not a particularly clear area. But for now, if you're having advertising material prepared by third parties, you should ask the question and make sure that you know if it's being prepared by AI. If it's using material or voices, there could be a misrepresentation or a misappropriation to use those materials. For example, if the AI has used someone else's voice. There's also a bit of doubt about who owns the copyright in AI generated material. So you want to make sure that you've got the right to use it in your advertising. As I mentioned before, businesses can be held responsible for posts or public comments made by others on your social media pages. So in copyright law, there's specific liability which arises for authorising someone else's copyright infringement in circumstances where you know or have reason to anticipate or suspect that something infringes someone's copyright. So there's a number of matters to be considered in determining if someone's taken to authorise a copyright infringement. These are where if it's within someone's power to prevent the infringing act, the nature of the relationship between the authoriser and the infringer, and whether reasonable steps were taken to avoid the infringing act. So it seems entirely possible that businesses conducting a social media page may be seen to be authorising copyright infringements that occur in the posts or public comments made by others. This could be in the form of a meme or photo that someone puts in, for example. So while you're monitoring your social media for misleading or deceptive conduct in the comments, it's best practice to also monitor to look for potential copyright infringement. It's then expected that if it's in your power, you take action to remove that any material. So you only need to make reasonable checks, but just don't be different about what people are putting in place. I just want to talk just quickly about trademarks. It's one of my favourite things to talk about. So it's likely that any digital advertising will contain some trademarks. A trademark is a sign or symbol that's used to identify and differentiate a brand. So this is things like business names, product names, logos, and taglines. So first, we've got your advertising material. You need to see if it contains any trademarks that belong to others, or that are substantially identical or deceptively similar to a trademark that belongs to others. If there's such a trademark in your ad, then careful consideration then needs to be made about whether it's being used as a trademark. So use as a trademark means use as a badge of origin in the sense that it indicates a connection in the course of trade between your business and the goods or services being advertised. So using a phrase descriptively, even if that phrase is also a trademark, will be acceptable. So for example, the High Court found that the phrase instant Botox alternative used on a Protox product, that wasn't used as a trademark, and it therefore didn't infringe Botox's many registered trademarks. So you're looking at whether the other person's trademark that's on your advertising is a sign or any signs which are substantially identical or deceptively similar. You're looking at whether that has a branding function in your ad. If it does, then it will be infringing the other person's trademark. So obviously you don't want to use it. So the nuances in determining whether or not a trademark is used as a trademark can be a bit tricky. So the safest course is probably, if you've identified someone else's trademark in your ad, is probably just not to use it. To be quite certain about whether you're using other people's trademarks, you can search the trademark register with reference to any phrases or images in your ad. There's like an image upload you can do on the register. So if there's any parts of your ad that you think you're using something as a trademark, you can check it against the register to make sure you're not infringing anyone else's. So once you've identified any trademarks appearing in your ad, so signs being used as a trademark, and you've also ensured that no one else has a substantially identical or deceptively similar trademark, then it's advisable that you register those trademarks for yourself. So just briefly, registration gives you exclusive rights to use the trademark, put others on notice of your ownership of the trademark. You'll be able to use the R in a circle next to the trademark when it appears in your ad, and that indicates the trademark is registered. Even if you don't register the mark and you want some acknowledgement that you're intending to use the sign as a trademark, then you can use the TEM afterwards. Having a registered trademark can also assist to ensure that others don't use your trademark. And registration provides a remedy for infringement if there's other people in their advertising or other things in the course of their business that are using substantially identical or deceptively similar signs to yours. And that puts you in a strong position if you've got a registered trademark than trying to make a claim against someone when your trademark's unregistered. So ideally, you've got your social media handles for your business. They'll be aligned with your registered trademarks, and thereby that strengthens the reputation in your brand and makes it easy for people to find you. Social media platforms, obviously a good avenue for digital advertising. They can be utilised to deliver targeted messages to specific audiences. But each social media platform has its own terms and conditions governing use of the platform, including special rules usually for using it for commercial purposes or advertising. So commonly the social media platforms require you to grant a license to them for all the content you upload that's covered by intellectual property rights. So for those who don't know, intellectual property rights are rights over creations of the mind, and it's anything from like inventions to artistic creations. And we've mentioned already the main forms of intellectual property in advertising is copyright and trademarks. So you give this license to the social media company, and that is usually really broad. They're obviously allowed to distribute, use and upload the content, like that's what the license is for, and they need that necessary for the platform to work and for your ad to be circulated. But the license often also contains rights to modify and adapt the content as well. I don't think that Facebook and Twitter aren't generally in the process of doing that very often, but the right is there. Each platform often has specific requirements for advertising, as well as its use for commercial purposes generally. So you need to ensure that you're complying with the rules of that platform when you're advertising and promoting your products and services. So as an example, Meta's terms, which applies to Facebook and Instagram, requires that ads not be misleading, nor should they imply an endorsement by Meta. There are also prohibitions, as you'd expect, about not having ads which are discriminatory, sell illegal things, or contain nudity and things like that. A further requirement of Meta is that advertising not contain content that infringes the intellectual property rights of any third party. Meanwhile, TikTok makes access to its platform conditional on not using its platform to infringe on anyone's intellectual property rights. So you can see, like, to some extent, the terms and conditions they're putting forward is just a reinforcement of the legal obligations that businesses already have, as we covered earlier. But by including them in their terms and conditions, like, I mean, the platforms, they have the appearance of doing the right thing. They can also absolve themselves of some responsibility, but it does also allow them to remove content which they consider breaches their terms. So in relation to copyright, intellectual property rights infringements, this is usually affected by takedown notices, which some of you might be familiar with. So where a person claims that the content of an account holder infringes their intellectual property rights, they can file an online takedown form to notify the platform that their rights are being infringed. The processes differ slightly across the platforms, but generally the content's initially removed, and then it's open to reinstatement if the account holder files some sort of counter notice or appeal. But then if no legal action is taken by the person complaining within a certain time, they'll reinstate the. So by implementing all the checks that we've already talked about for ensuring your digital advertising complies with the Australian consumer law and doesn't infringe copyright and doesn't utilise copyright materials of others and doesn't infringe trademarks, then you're less likely to have this takedown notice issued against you anyway. If you do, you can lodge the appeal notice and be pretty confident that your ad will stand up. Better for you if you can use these takedown procedures to assist your business and protect your rights. And to this end, it's important to be monitoring social media and the activities of competitors so you can quickly start these processes to protect your intellectual property rights. Also, of a bit of interest with Facebook, they have these special rules for running a competition, which you might want to do as part of your promotion. And they include that you cannot ask entrants to share posts on their personal timeline or to tag people in order to enter into the competition. So you can only encourage users to name friends or share the post, but you can't make those things a requirement for participation in the competition. What you can do is ask users to comment on a post, like tell me your best experience at Wally World, whatever it is, or they can like a post in order to enter the competition. Also, as part of the terms and conditions, you can't limit your competitions to paid subscribers if you're advertising on Facebook, and it's your responsibility to comply with the laws and regulations. Of course, the Facebook doesn't want that responsibility. There also has to be an acknowledgement included in the promotion to say that it's in no way associated with Facebook, and each participant has to give a complete release of Facebook. You should also generally have terms and conditions for running a competition, and you should put a link to them in the ad to be transparent. Looking at a few, just briefly, little anomalies and rules. Social media influencers or brand ambassadors can be a really good way to advertise your business or products online. Some people have a budget for influencer marketing. I don't know if any of you are using influencers for your marketing. But the ACCC, in addition to regularly checking online advertising, is looking closely at social media influencers as well. So an influencer's omission of an underlying commercial relationship or incentives they're receiving to promote a business, or even if they're disclosing these things, but it's in a confusing way or hard to notice in their post, is likely to be seen as misleading conduct in breach of the consumer. So It's recommended that as a business, you take regular checks of any ambassadors or influencers you're using to ensure that they're complying with everything they should do. And that's like disclosing from the commercial relationships, clearly disclosing in a promotional post, instances where the influencer has received free products or tickets or any other gifts. They should also not make misleading claims about products. So this means they can't misrepresent their experience with the product and say something was awesome when they thought it really wasn't. And they shouldn't be using manipulative or deceptive advertising practices. So if you're using influencers, just make sure you're checking. Therapeutic goods. Marketing for therapeutic goods is a really heavily regulated area. Therapeutic goods are all health-related products, including those to prevent, diagnose, treat, or alleviate illnesses or diseases or injuries, as well as things that influence contraception or influence or inhibit or modify psychological processes. So this incorporates a really wide range of goods, and is anything from band-aids and vitamins to prescription medicines as influence. So some therapeutic goods, including prescription and pharmacist-only medicine, there's a complete prohibition from being advertised directly to the public. Advertisement is really broadly defined, and therefore, like a social media post or a marketing email is probably going to be considered an advertisement of a therapeutic good if it contains a therapeutic good. And then when therapeutic goods are able to be advertised, they have to comply with the advertising code that's made under the Therapeutic Goods Act. This includes ensuring the information provided is truthful, balanced, and again, misleading. Amongst other things, it also requires certain information to be prominently displayed or communicated in advertisements depending on the product, and it's different for every product, and prohibits certain representation being made in advertising without permission of the Therapeutic Goods Administration. In addition, there's special rules that apply to advertising that's usually done by influencers. So if an influencer is being paid for their promotion of a therapeutic good, they may endorse the product, but it cannot be advertised using a testimonial by the influencer or other persons engaged in marketing. The difference being that an endorsement is an indication of support or approval for the product, whereas a testimonial refers to a statement about a personal experience when using a product, such as product X always helps me get rid of my headaches. So they can endorse, but they can't give testimonials. And financial products. This has come to the limelight a bit in the digital media space following a number of trending social media investment and tax advice posts, including one which advised people to obtain an APN and lodge a BAS outlining more tax and get a GST refund. Apparently, some people thought this was legitimate tax advice, that you could just do that. As with advertising generally, advertising of financial products must not be misleading, it needs to be accurate and balanced, and importantly in this area, not make predictions which are unable to be substantiated. So financial products, to take a step back for a minute, things like credit cards, loans, term deposits, shares, and other financial investment vehicles. So influencing someone's decision to invest in a particular financial product will be the provision of financial product advice, and you need to be licensed. So if your business provides financial products, you're likely already licensed to give financial products. But I guess the nuances come when you've got an influencer or ambassador, or if you're sponsoring someone and they're promoting your products, because then they'll be acting on your behalf and they'll be your representative for the purposes of financial services. Having a representative then triggers like a number of obligations, such as ensuring they're adequately trained and are acting in compliance with the laws. Again, like if you've got an influencer or sponsor or someone, then you have to monitor their online activity to ensure that they're compliant, and that will limit your liability as a financial advisor. One question that often arises is whether your business can use various email addresses it has obtained for the purposes of direct marketing. So you might have obtained an email address through your website, but when a customer creates an account or purchases a product, or you might obtain it off a business card, such as when you get guests to put business cards in a draw prize, or competition entry forms, or many other things. Sometimes you can obtain them through third parties, such as if you host a ticketed event like that and use them for ticketing. So the starting point is that an email address of an individual will be personal information under the Privacy Act. So you're required to comply with the Australian privacy principles. So if you're already required to comply with the Australian privacy principles, then you need to handle the email addresses you obtain in accordance with these principles. So a business will be required to comply with the Australian privacy principles, or the APPs, if the business is an APP entity. So generally, there's some exceptions, but it's generally an organisation that's a small business operator, which means they have an annual turnover of 3 million or less. So 3 million or less, you don't need to comply with the APPs, but if you're over, you do. Unless you're a health service provider, and then it doesn't matter what your threshold is, you have to comply with the APPs. So APP 7 specifically deals with direct marketing, and this principle generally, and again there are some limited exceptions, but it prohibits use or disclosure of personal information for direct marketing. However, this principle doesn't apply if the Spam Act applies. So the Spam Act governs sending of what's called commercial electronic messages. So a message sent by email and also messages sent by social media or text will be an electronic message. So bear in mind that the Spam Act, unlike the privacy principles, applies to all organisations, regardless of whether you're an APP entity or not. So these electronic messages, so those sent by email, social media, or text, things like that, they'll be commercial electronic messages, where if having regard to the content and presentation of the message and the content that can be located using links and telephone numbers in the message, if it would be concluded that the purpose or one of the purposes of the message is to offer to supply goods or services, advertise or promote goods or services, or advertise or promote a supplier or prospective supplier of services, as well as advertise or promote a business opportunity or investment opportunity, and there's many other listed purposes. So this is extremely broad, so even a soft sell in any electronic message is likely to render it a commercial electronic message. For anyone still collecting fax numbers, fax numbers are not considered commercial electronic messages. So that would just be governed by APP 7 if you're an APP. So under the Spam Act, there's a general prohibition on sending a commercial electronic message with an Australian link, unless it's a designated commercial message or the receiver's consented. So the Spam Act also expressly prohibits use of an address that's been obtained by address harvesting software. So other than that, you can send a direct marketing email if you've got consent, or if the message is a designated commercial electronic message. I'll deal with consent first. Consent can be expressed or inferred from business or other relationships. For example, if someone bank tells them about a new savings account product with a higher interest rate. Consent can also be taken to have been given to receive messages if the email or other electronic address of a particular individual is conspicuously published. So this isn't defined, but it's likely to mean it's published in a way that's readily and publicly available, and not through like a subscriber web page or something like that. So to use a conspicuously published email address, it also needs to be reasonable to assume that the publication is with the consent of the individual. It's not accompanied by a statement that says the individual doesn't want to receive unsolicited messages, and the message has to be relevant to work-related business functions or duties of the individual concerned. Consent can also be withdrawn with 5 business days notice. So Then we'll move to the concept of a designated commercial electronic message, and that's a bit more complicated. There's a whole schedule in the Spam Act that talks about its meaning. But the main requirement is that the message consists of no more than factual information with or without directly related comment. So on some views, this is really narrow and is limited to solely transactional messages, like acknowledging an online transaction would be spam, or confirming like your purchase of a product or service, or even advising how to reset a password. So that's the narrow view. This can only do it for those things. However, that those sorts of things, if they're not accompanied by other matters, it seems difficult to see how they could have purposes with the marketing flavour to be a commercial electronic message in the first place. So that's probably too narrow interpretation. The better view is that designated commercial electronic messages could be newsletters or updates with information to benefit the community. So things like a medical clinic sending an electronic message containing information about skin cancer prevention, that should be considered provision of no more than factual information, and therefore a designated commercial electronic message and allowed to be sent. You can include a really limited list of things in a designated commercial electronic message that contains that sort of information. Like just your logo details or a sponsor's logo if it's sponsored. That should still be okay. However, a link to a website probably goes too far. So taking the above example of the skin cancer prevention information sheet, if there was a link in that message directing the recipient to a website to purchase sunscreen, then that probably puts the message outside the designated commercial electronic message exception and is not able to be sent without consent. So even where you can send a commercial electronic message, you're required to contain a functional unsubscribed facility in that message that complies with the Spam Act. So then if you've determined that the type of message you want to send and the person you're sending it to complies with the Spam Act, then if you're an APP entity, there's still some further APPs that you just need to have in your mind. You have to consider the purpose that you obtain the email address for. So generally, personal information like an email address can only be used for the purposes for which it's collected. There's some exceptions to this which allow use for another purpose. And this is called a secondary purpose. So the exceptions are if the individual has consented to the use for the secondary purpose, if it can be reasonably expected that the information be used or disclosed for the secondary purpose, and it's related to the primary purpose of collection, or if it's sensitive information, which is like health information, criminal records, things like that, then it has to be directly related to the purpose. And then there's some other limited circumstances, like if it's required by law or in the event of a permitted health situation. So this means that if you're an APP entity, where you've obtained an email address for the primary purpose of a person creating an account, for example, like to access information relevant to a course the customer is undertaking, then it cannot be reasonably expected that the email address be used for purposes of direct marketing. And it's best to obtain consent of the person before sending direct marketing material by email. It's best obtained as an express consent, even though it can be more difficult to work. So where a person's creating an account for the purpose of purchasing products, then the analysis might be a bit different, because it seems more likely that this person would reasonably expect that the email address supplied would be used for the purposes of direct marketing of those products, probably of products of that organisation generally, although possibly not products of another business. So it's all about what the expectation would be. In addition, again, if you're an APP entity, APP 5 requires individuals to be notified of certain things if it's reasonable in the circumstances. This includes the identity and contact details of the APP entity, the facts and circumstances of collection of the personal information, and the purposes of such collection. So depending on how you obtain the email address in the first place, you might have already completed this requirement. But if not, it's something to bear in mind to include in the marketing email itself. As you can see, like the legal landscape of digital advertising is complex and multifaceted. From ensuring compliance with the Australian consumer law to avoiding unauthorised use of copyright materials, there are many things to be aware of when developing digital media advertising. I've covered a few of the main issues to bear in mind and a few little nuances, but it's crucial to recognise that legal implications extend far beyond these examples. So a quick summary of the main points are things to take away. Ensure promotional materials contain complete, clear and accurate information and do not mislead or give false impressions. And remember, this includes images. Do not indicate a sponsorship or approval that does not exist. You should obtain an assignment or a license of copyright in your promotional materials. Make sure you take care not to use trademarks of others. Pay attention to social media terms and conditions and also stock photo terms and conditions. You should monitor and remove unlawful or infringing comments on social media, but do not selectively remove or edit your bad reviews. You should monitor any influencers and you should obtain consent to use of emails for direct marketing. That's the easiest way to comply with those things. So my best takeaway message is to approach all your promotional materials with scrutiny and really careful consideration. But while your main aim is to capture the intention of your target audience, it's also important to ensure that every element, from the visuals to the language, is legally sound and compliant with all relevant laws. By doing so, you can protect your brand's reputation and avoid legal disputes, as well as creating your effective promotions. We can see how it's like, yeah, we can chat out.
However, anyway, I work in science.
Yeah.
We're doing now some things. How it does apply, like, I work in the world of microbes. We take pictures of microbes that nobody has seen before or whatever. We use scientific names and this and that. We create the pictures and all that, but we put it in Twitter. We never mentioned the commercial products where these items are coming from. In that way, I'm not mentioning before the commercial products that these methods are coming from. Do you think?
Well, depending on the content of a particular thing you're posting and what it looks like. It's not really promoting anything. So
no, really, except for the companies. That is,
yeah, it's not misleading.
It's not misleading.
Yeah. Yeah. So then you think about trademarks and if you've taken the photo,
yes,
yeah, depending who's the owner of the business and stuff, there's copyright issues.
Okay.
Yeah, so it's just a matter of going through all things in the context of each post that you do.
Okay, thank you.
That's good.
Scenarios, customer reviews. Right?
Yes.
We've got a visions, we've got stockists as well. And so the stockists that have got their own businesses have collected customer reviews on their own website. And we're the owner of the actual product. Do we have to get permission of that business to use their customer reviews for our own product? Because they've collected the reviews. Or are we able to use their reviews with the person's name still attached to it, which is public, so we're not able to get permission for that?
It's probably better to do that. It's always better to seek consent and permission. Sometimes we get to do that because I think it's not. That person actually wrote a thing.
Yeah, it's a truth.
Depending if it's got copyright or not.
So collected it.
But that person, they've written a whole big thing, then they've got copyright in that, which they've really only licensed the stockist, if I understand the facts correctly, and so not to you. So the stockist might not even be able to if they've got copyright. That's technically, yeah.
It's just always best to ask, it's, but, yeah, just ask them. Thanks.
Just got a question under the misleading or deceptive conduct specific to warranty claims on products. So the business I work for, we're in the process of bringing in a whole lot of new products for the business, and with that putting together detailed spec sheets. And in the spec sheets, a huge thing for a builder in this instance is to see not only the specification, but once installed and appropriately installed, what is the warranty of the product. And the spec sheet is a spec sheet, not conditions of sale explicitly, yet that we do have a conditions of sale warranty document, which is separate too. My question is, for us to mention in the spec sheet, which is prior to purchase, making mention of the warranty in question, and then referring them, because this is the part that's triggered me here, is it's not enough to clarify the fine print. The nature of this document is specification and to show that there is a warranty.
Yeah.
In addition to this document, there is a conditions of sale or warranty, which includes the conditions of sale, which will stipulate in detail the T's and C's, which they say are specifying their terms and conditions apply. But there is a document which is a supplement to this.
Yeah.
It is full of rigor, and to include that in the spec sheet, I think would be, it's not part of the spec sheet.
But you do it.
So we just make mention of the warranty.
Yeah.
And then Ash just,
You don't want to include the whole thing.
and then say referring to clause 10, which is specific of the conditions of sale. And we don't include it in there, but if they want it, we've got it.
I think it's the most important thing is to not like hide it at the bottom, clause 10 of the thing. Like if you say pursuant to clause 10 of my thing in bold,
Yeah.
it will give you more detail about the
So that's
warranty.
not hiding.
Yeah, and then it's not misleading.
Because I'm not guessing we don't include that information in this particular document, but a supplement to it.
Yeah, so as long as you're clear about that, there's more detail around this that you have to get from somewhere from another document.
Okay.
But yeah, you have to be careful with warranties.
Yeah.
What if we include like an asterisk and have an asterisk down the bottom of the fine print? So
That's what I've done in this instance.
That's basically what Optus did and it didn't work. So it depends on the like what you're trying to sell and what conditions. But if I'm not very good at thinking of examples off the cuff, but if it's the condition is really onerous, then which it was, that's what they said in the Optus case, that it wasn't unlimited, like you're saying it's unlimited, which is a really big claim. So that's like the 100% claims and things like that. So if you're making a big claim and you've got a really onerous condition that you're being infringed, that's not okay. But if you've got if it's the claim's not so outlandish, then you can put an asterisk with the thing, but not too fine. Like so it's all about context, like weighing up the different perspectives. Just at the end of the day, as long as it's not misleading someone or giving a false impression about something. And lots of people say terms and conditions apply, but it's depending on what you're comparing that to and how onerous conditions are.
Can the influencer who you're paying give a testimony for your product if the person is actually using the product, or?
Yes, just not with the therapeutic goods.
Why not? If it isn't there?
It's because they're so heavily regulated, because they're health products. Yeah, the therapeutic goods act is strict around that sort of thing. Other things is fine, yeah, do it. But as long as it's not misleading and they're being honest, not misrepresenting their experience with the product. Okay, thanks everyone.
Too many things to juggle.
Some of the things that I'll share.
Lots.
This is how interesting, by the way. I'm thinking, how did you affect people? I'm not. So we have
For some time.
So yeah, quite serious. You're not serious. Yeah, well, yeah, thank you. I do it. They're very not. And you. No, really popular. Yes.
It's also cheaper, but it's what.
That's the bad. Yeah, so yeah, let's say I'm here.
It's a big.
I do this. So I.
No, wow.
You have.
Well, this is trying to change. State essential.
What else? It's. Well, if we fix. What should we do?
Yes. Yeah, we still, I'm saying, one of the main goals. See on systems.
Yeah, I choose.
What's the right? And the leaves.
You like urgency.
And if we so
I mentioned that to ask that time to damage.
Yeah. Like, so it's like as a category, it's yeah.
Thank you, I have you.
No, like, see what, like if your licensing, you can upload. I think that's the main thing.
I'm sure, yeah. Can we take the two ones?
Okay, we don't know. Yeah, also.
Wait to see anyway. Oh, it's very good.
So,
I think it's for the thing. Oh, yeah. Yeah.
students, then I think, your, we're still awkward all the time. Oh, slowly.
Yeah.
That's like,
Yeah.
he's doing it right. I shouldn't have what you're going and pointing out here something about 3 days for music to set.
This was it.
Yeah.
I find there, the one that's Ukraine, the one that's trying to play all of the people here that with
Thank you.
Thank you.
Yeah.
Yeah, I do remember. Yeah. I love you. Thank you. Yeah.
On someone.
Yeah. So, yeah, do you know what I mean? We would be. Maybe no. Usually with them on, sometimes it's. Yeah. Sorry, it's very cool. Yes. We often get the door, once we call that we. There's a cheat that has some strong pressure to help them, but that's part of that. So, yeah, to make content for those people that engage. It's really hard. And I'll customer. Yeah. Yeah. So you see that, that's like.
I find it.
Yeah.
From
this.
Right.
Yes, a good excuse. Also, when you need. Side things.
Cats out.
Oh, yeah, you know, yeah.
Sorry.
Yeah.
Like,
Well,
they obviously, you know,
Valentine's
I never, so
Day.
which is my sentence. Wanted to, they'll actually give me better promotion and reach with approach.
I've got an AV, but I'm not too sure if I can just park. So, yeah. I've never had to do it.
And make it work. Like, but I'm saying you need to keep.
Yeah, that's the only issue, and being lunch, everyone sort of was starting.
See a website. And then there's.
There were not like.
Okay.
Yes, okay, but-
So put it on the.
Thanks,
Post. Yeah.
Sort of
Yeah.
EB.
be like.
Oh, yeah.
See you.
Yeah, no problem. You have to.
It's short, quick, sharp, share.
Yeah.
Yeah, so the what that was,
We went to check
and
them,
then
and then they went.
promote you to do it. Yeah, yeah,
Well,
yeah, so that's all up there. Nice. Alright,
We need to get the next car. It's crazy. Yes.
Just away. You're surprised? I'll get out.
Yeah, my parents
Get it out.
like solar and then a battery on their home.
Thank you so much.
Well. Yeah. 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 That's.
Excuse me. You nearly wore that one. But once again, mate, thank you so much. Yeah, yeah, never really opened up. It's good. It's right. I appreciate that. Thank you so much.
Then
Yeah.
Okay, so I've got
No, sure.
so much, yeah, it's lovely. See you soon.
That's massive. It's like the last year, the last. Well, sure, sure. It's certainly right. Always does that. Leaves it to the last second and sends something through. The actually pages.
Yeah. Okay, now, so.
It's on you, but you don't have emails tonight. I've left my old phone. So class. The whole stuff of network. I can go into that. And I'm going.
Yes, so sorry, I might actually watch.
Yeah, so I just closed the power. We're very stressful, but I didn't sign all that other part of the just get it.
about
So can't see it either. Yeah.
now that's
Okay,
Okay.
okay.
Yeah. Yeah.
Yep.
I reckon another 3 times. I really stopped.
Yep.